Drake's copyright lawsuit against UMG over Kendrick Lamar's Not Like Us was dismissed earlier this year after the district court found his claims legally insufficient. He has since appealed that dismissal to the U.S. Court of Appeals for the Second Circuit. As part of that appeal, the court has now issued an order requiring both sides to participate in a formal mediation session. This step does not revive his claims, but it does shape what happens next in the appellate process. The Second Circuit's mediation order comes through the court's Civil Appeals Mediation Program, known as CAMP. It is a routine procedural step that the court applies to many civil appeals, especially when the parties are large commercial entities that may have the capacity to negotiate. No party asked for this mediation. Drake didn't file a motion for it. UMG did not file a motion for it. The purpose is not to decide whether the lawsuit was right or wrong, or whether the dismissal was right or wrong, but to explore whether the appeal can be resolved, narrowed, or settled before the judges spend the next year on full briefing, argument, and decision. The order requires counsel for both Drake and UMG to participate in a confidential 3-hour mediation conference conducted by the court's chief mediator. Only the attorneys attend unless the mediator specifically authorizes or requests client participation. The conversation is confidential and cannot be disclosed to the public, the press, or even the judges handling the appeal. Nothing said in mediation becomes part of the public record, and it has no bearing on the legal merits unless the parties reach an actual settlement. Mediation does not pause or slow the appeal. It's part of the process. Drake's legal team must continue preparing the appellate briefs on the standard schedule. The camp session simply runs in parallel to that. If the mediation narrows the issues or leads to a resolution, the court benefits from saved time and fewer contested questions. If the mediation goes nowhere, the appeal proceeds exactly as it would have otherwise. In short, the mediation order is not a signal about the strength or weakness of either side's position. It is a standard administrative step that gives both parties a structured opportunity to settle or streamline the case. The real action remains in the briefs that will follow. They haven't been filed yet. And those filings, not the mediation, will ultimately determine whether Drake's appeal has any chance of reviving his claims against UMG. So, in the end, the mediation order doesn't mean Drake is winning, losing, or even moving the needle. It simply forces both sides to sit down, talk, and confront the practicality of this appeal before the court invests real time in it. If there's a deal to be made, camp is where it happens. If not, the fight continues forward to the briefing stage, where the Second Circuit will decide whether this case gets a second life. And if you came here rushing, wondering, what did I miss? The answer is simple, beloved, nothing major yet. Just the court pushing the parties to handle their business before the judges step in.